Welcome, everyone. My name is Julia Chalker, and I'm the District Transition Specialist here in Prosper ISD. And I'm very excited about the training today that we're doing, and it is about guardianship, alternatives, and other legal issues for special needs. I'm very excited about our speakers today, and just to give them a quick introduction, we have two local attorneys that specialize in estate planning, and they work with families navigating that whole guardianship process. But they both also really have a heart and a desire to help others. You can tell that from their background. We've got Eddie Caulfield, and he's with the Caulfield Law Firm in downtown Salina on the Square. He was honored by Texas A&M University School of Law as a fellow for his performance of public interest legal services to those in need. And he's fluent in Spanish and has won the distinction of D Magazine's Best Lawyers in Dallas and Texas Super Lawyer. Paul Grenier is with the Grenier Law Firm here in Prosper, and he actually worked in the school setting for 10 years before he went back to law school because he wanted to find ways to give back to the community. And he finds that guardianships are another way to serve local families. He currently serves on nonprofit boards and advisory committees in Prosper. So they're very qualified because of their legal background, but also their heart to serve. So we are glad to have them here.
Which is the introduction to guardianship. There, in Collin County, about 85% of guardianships are primarily a guardianship of the person, and they are when a 17, soon to be 18-year-old will be having a birthday, and on paper they're going to be an adult, but due to a medical condition or some other event, they're not able to represent themselves, to function legally speaking as an adult with someone without that incapacity. And so at that point, they need some assistance. And there are two types of guardianships in the state of Texas. There's guardianship of the person and guardianship of the estate. The vast majority, and I imagine Paul would concur, of the guardianships that we do, and certainly the ones that we do for individuals who are entering adulthood, are limited to guardianship of the person. And so that'll be primarily what we talk about here. And there's some things that we do to make certain that a person who is identified as the proposed ward, the person who needs the guardian, to limit their assets on paper so that they stay below a threshold of about $2,000 in assets, so that they can receive some benefits and services and continue to receive those. And so by not having an estate, we're able to limit it to a guardianship of a person. They're able to get those services. And two, it makes it a lot easier on the guardian. Guardianship of the estate is typically more when we're doing a guardianship for someone, it's a much smaller percentage who maybe is very late in life, and maybe due to some dementia or Alzheimer's, they need a guardian. They may have some measure of assets they've accumulated over their life, or maybe have a home that's an asset that would need some protection, and that requires a little bit more oversight from the court to make certain that those assets are protected. And so in a nutshell, there are two. We'll focus primarily on guardianship of the person, and typically we're going to court and asking the court to appoint, most of the time it's a parent or parents of the individual to be appointed as their guardian. Occasionally, it doesn't have to be a parent or parent. Sometimes it's a sibling, another designated individual, and there are professional guardian companies out there who do very fine work. I would say statistically, those are oftentimes utilized more often when someone does have an estate and it's an older individual. But it's a very powerful procedure, which is why the court asks us to look for alternatives. The law requires that on the front end, which Paul will touch on in section 2. But when you become someone's guardian, it's very powerful, and it gives you the authority to make a lot of decisions for the individual throughout the course of their life. And if we go to the next slide, it's, as I mentioned, it's typically when somebody turns 18, legally on paper they're an adult, and they're unable to make these type of adult decisions and transactions that they otherwise would be able to. And those are important decisions about where to live, their medical care. And the law requires a judge to make a ruling on really 4 specific areas. And that is, are they capable of making a decision on their residence, on whether or not to get married, on the ability to vote, and on whether or not they will operate a vehicle, which certainly presents the question that there may be instances where somebody may be able to do some of those things. And I practice primarily in Collin County. Paul does as well. However, we find ourselves in outlying counties. We're fortunate to have Judge Copeland in Collin County, which generally speaking just makes this a very smooth process. But he's real good about doing a limited guardianship. And if he believes that if the DPS will give someone a driver's license, then and the parents are okay with that, or the guardians are okay with that, then he'll write that in there. That they're gonna reserve the right to be able to get a driver's license as long as the Texas DPS says so. And he also loves when people want to continue to vote. And his bar is essentially, if they can tell him who the president is, he's more than happy to maintain their right to vote in the paperwork. And if things change over the years, then that can be adjusted as we move forward. Common conditions, so this is not an exclusive list, but common conditions that we see for folks who benefit from a guardianship, or severe autism, Down syndrome, any other intellectual disabilities that just generally prevent people from taking good, proper care of themselves, deciding where they're going to live, and making certain also that they're protected from anybody who may be doesn't have their best interest at heart. So in a nutshell, that's the basics of it. Again, if you have any questions on that, jot them down, and or raise your hand. We're more than happy to address those. I will now turn it over to Paul, and he's going to talk about some alternatives to guardianship.
Paul, we can't hear you because you've muted your microphone.
Thank you. Sorry about that. I said I'll be quick. And ultimately, this is a capacity question for us as attorneys, and really should be for you guys as well. Do they have the capacity to really care for themselves, even under these alternatives? So I've listed a few here. The middle one is more of a category. When you begin to think about decision-making support or person-centered planning, this is going to begin to beg some estate planning questions for you. And in this case, typically a minor child or one that's about to be emancipated to a major or to an adult. So specifically, Julia wanted me to bring up supported decision-making agreement. I still find that these are not widely recognized with banks or other institutions. And again, it goes back to, does the person have capacity? The statutory form still includes, at least as far as I know right now, I haven't checked in a few weeks, but the supporter, the person who is meant to support the potential incapacitated person, cannot make a decision. They're only there to assist, and their authorization ends there. In the end, the verbalization and the decision still comes from the person whose capacity is in question. So I'm finding institutions are not acknowledging it. And so you're meant to help this person make a good decision, and the institution's saying, I don't care what assistance you think you can provide, I only want to talk to them. And that does raise the risk of, is this going to negatively affect this person's life long term? Guardianship alternatives are really pushed very hard in Tarrant County. They're not so hard or pushed so hard in Collin. Denton has increased their inquiry, at least for me, into how I accommodated, ensuring that the alternatives have been addressed and been found to not be reasonable for the potential ward. Again, I find them very risky, especially powers of attorney, because they have to have capacity to execute these documents. The next slide, I talked very briefly about trusts, or at least those are the bullet points here. These are not alternatives to guardianship as a whole. They could be alternatives to portions of a guardianship. In other words, if the guardianship is only over a portion of the person and the decisions they make, a management trust, which is typically established by the court, that is something that can be used to augment the guardianship that the court approves. The other thing is a special needs trust, which can also be used to, as Eddie alluded to, limit the exposure of the ward's estate so that they do not lose government assistance or government funding. So it's very important when you begin to plan the estate of the ward, and honestly for you as the parents, if you plan to give money to your child, please think twice about it if they're going to be receiving government assistance. And know that guardianship long-term, if the person has to be cared for long-term, even beyond your own lifespan, you're gonna wanna contact some attorney to make sure that they're thinking about long-term money and how best to utilize either what's available from the government or what your estate can actually long-term provide for the potential ward. And I'll turn it back over to Eddie.
So now we'll go to section 3, and it's titled 13 Steps to Complete a Guardianship of the Person. There are 13 here. Arguably, there may be a few more here and there. And it seems like a lot, but once you've identified, and this is really sort of number one, is hire an attorney. You know, whoever you really, the law is not going to allow you to even move forward this because of the duties that come with being a guardian. But you need to have an attorney who represents you in the guardianship. They represent the applicant, the one who is asking for the guardianship to be in place for the individual. So you would be the applicant as the parent who is then asking the court to appoint you as the guardian, or many times both parents as co-guardians. Because there are very specific procedures and deadlines that must be met, it's vital, and it's way too complicated. I mean, you could figure it out, but the law's not going to allow you to, unfortunately. And there are just things you want to make certain that you just don't get your sweater snagged on as you're going through this process. But number one is really, and Paul touched on this, is determine if they're incapacitated and in need of a guardian. And you many times when folks get to me or get to Paul, that determination is either clear or it's been made. The law requires us to look for alternatives, but many times it's clear. And again, Paul touched on a perfect point there. One of the alternatives is a power of attorney. But if they're unable, if they don't have the capacity, either due to their age or to their intellectual ability, they can't execute one of those, and so it's not going to be useful. And so many times it's quite clear that someone needs a guardianship, certainly when they get to us. And it's if they can't independently care for themselves as it relates to their person, and again, if they have any assets, then that's really the bar. Every county is a little bit different on how if it's going to be a full, complete guardianship, or if it's going to be tailored and limited. But that's really the bar, is that if they can take care of themselves. Now, when you do, just because you want to be the applicant does not mean you're going to be allowed to. Now, again, that sounds more dramatic than it actually is, but must be 18 years of age. Most certainly, anybody here, you're certainly 18 years of age. And it's, as I mentioned earlier, it's usually a relative. It's almost always a parent. And many times, both parents as co-guardians. Could be another private individual, or as I mentioned, a professional guardian, but it's typically not. And really, you're there to serve this is legal language, in the best interest of the ward. Things that can disqualify someone from being a guardian are what the law calls notoriously bad. You don't need a lawyer to tell you what those things probably are. If someone has been found incapacitated by a court themselves, not going to be a guardian. You cannot be party to any lawsuit involving the proposed ward. The policy behind that is somebody in a lawsuit, and then it would be a significant conflict if they were able to be in control of the proposed ward, or just generally found unsuitable by the court. Again, these sound more dramatic than they are. Anybody applying to be a guardian, there are certain other folks who would require to be notified of this, and occasionally we'll have somebody come in and jump in and say, I don't think that person's the right person, it's me. And then we will handle that as we go from there. The part of the application, and I keep talking about this application, it's something that's written by, and we'll touch on this, but it's legalese written by lawyers for other lawyers. And a lot of checkboxes are particular areas within the application that we address when we submit it to the court to begin this process. And what we submit alongside the application, and we reference this in the application, is what's called a physician's certified medical examination. It's commonly referred to as a CME, and it's usually provided by the proposed ward's primary care physician. And I think Paul does too. Most people, it's a standard document. There's a picture of one in here. I think it's just page 1 of the CME, and just about every pediatrician and most family medicine doctors, there it is right there. That's the first page of it. You'll see it's page 1 of 4. It's very standard. And the physician will go through there and fill that out. And then they will provide that back to you. You provide it to the lawyer, and that becomes part of the application. And in my practice, we don't get too far down the road until we get that. And that is because many times some of the information that we provide in the application comes directly from there. And in fact, we reference the physician and where they practice in the application, and a number of questions that must be answered under the law about whether or not someone needs a guardianship are answered in there. It says here the CME can expire within 180 days of the examination. And what that means is there's a default that the examination has to be done less than 180 days prior to the guardianship being granted. However, if the guardianship is due to an intellectual disability, a total intellectual disability, then the look back goes 24 months. But that's just something to be mindful of. Is many times I'm speaking with folks, and I know Paul is too, who they're just trying to work through this maze, and it's so much information coming at you, you don't really know where to start. We start with that, and once we get that done, things move very, very quickly. And then we also know that we've got this done on this date, and we're going to be fine. We're going to have it. Everything really starts to fall into place once we get that in there. The CME back from the physician. And then, as I mentioned, the application, and it's a lot of legalese. If you're having trouble sleeping at night, you can ask for a copy of one of these that's been previously filed from most courthouses. And they're all pretty standard and similar, but obviously everyone is tailored to the individuals. But you'll see it's just a lot of legalese as you move your way through about answers that are required by the legislature, which are then required by the court to get answered. But it gives basic identifying information of the proposed ward, the applicants, and we're also required to list information about siblings. It's called levels of consanguinity, and if it's parents and biological siblings or adopted siblings, we list them in there. And then that's where we will address the powers that we're asking for the guardian, or if there's some limitations that we may have a limited guardianship. We'll reference that in there. The CME's filed with that. In Collin County, we also file what's called a citation letter, and we ask the court to then generate, it's called a citation, that a constable will then deliver. I think Paul will touch on that here in a bit. Once the application is filed, then we get a case number. And in fact, I filed one yesterday after 4 p.m. And before we began this morning, we were emailed the guardianship, the case number for that guardianship case in Collin County. And then the notice of the guardianship is posted at the courthouse. You could argue this is a rather antiquated way things are done, but an actual citation is what it's called, is posted at the courthouse. 100 years or so ago, this is where people got their notifications. We still do it that way. And then once we've got the case number, you as the proposed guardians will be required to complete what's called the Texas Guardianship Certification course. There's a link in there through the JBCC where you're registering your guardianship, and it takes about 30 to 45 minutes. Oftentimes I will equate it to doing defensive driving online. It's not difficult. It walks you through it. If we're doing a guardianship of the person, by definition, the individual, the ward's assets are lower than 50,000. And when the assets are lower than 50,000, a very basic background check is done as part of this course. You really never even know that it's done. If the assets are above 50 and we're doing a guardianship of the estate, then you'd be required to do a more detailed background check involving fingerprint cards and things like that. You're not going to have to do that for guardianship of a person here. And then you're going to PDF of a certificate. When it's done, you give that to your lawyer. They will then in turn file it into the case. And then behind the scenes, your background check results get delivered to the court there. So that's a lot of me talking. I'm going to now pass it off to Paul to finish up section 3.
All right. So, and this is really not a substantial step. I don't find it for my clients, but you will have someone from the court come out and serve your child. It can seem like an awkward situation, but it doesn't have to be. This is, again, an illustration of the constitutional rights that they have as a person that can pose risks in the future. So this is just the final step, so to speak, where the court interacts with the ward prior to hearing. And it just lets them know, hey, you should come. In Collin County, I don't know if Eddie's talked about this yet or not already, but Collin County, Judge Copeland really likes to meet them. He gets a kick out of it. He loves to see them. He has a deep place in his heart for them. Denton County's a little bit different. I never know what judge I'm going to get, and they may not be a judge of the same caliber, so to speak. Some of them are CPAs. Some of them are not attorneys. So this is something that you work through. This is just service to the ward. The next step is going to be court investigation. This is when an investigator will contact you from the court. They will ask to make an appointment with you, and they will essentially interview you. And they're going to probably interview your child and talk to them a little bit if that's even possible. You're going to find also that the ad litem, when I get to that step, they're going to do a very similar thing. And this is just to make sure that all the legal requirements are met and that they're going to report back to the judge specifically on what their findings are. The next step is the ad litem. This is appointed by the court. I'm on the list for Collin County, and I love it. It's one of the best things I do. When he calls me up and says, hey, I have a case for you, go check it out. And I get to meet with the family, and I get to meet with the child, and as best as possible assess the need of guardianship. And I report back to the court. One of the things to remember is that in Collin County, for sure, down here at the bottom, it says there's an affidavit of inability to pay, and that can be filed with the court so that you don't have to worry about the ad litem fees. It could be pulled out of the court for, I don't remember what the fund is called actually. Eddie, you may know the name of the fund, but the court can cover that cost for the family. And then finally, there's a mandatory citation of notice to interested parties. And again, so he's talked about one already that they post to the courthouse. Another one can be that we have to send notice to, let's say, siblings. Instead of having to deal with the time and cost associated with sending all that out, when usually they're in the same house or associated to such a degree that we can get a waiver. And so if we can get a waiver of these parties up front, we won't send notice to them. So we can save time and money with the court, and we'll file the waivers with the court to let them know, hey, from now on, this person doesn't need to be notified on what we do for this guardianship from this point forward. So I personally find it easier to get waivers, and it saves time and money, at least for me and my clients, in my opinion. Let's see, what is the next one? The next is going to be the documents. I'm not going to go specifically through each one of these, but this is a list of some of the documents that we filed. You'll notice there's a rental agreement as well. This is something you should consider when you're receiving government assistance. I know it sounds ridiculous that you would say, hey, I'm going to have my child pay me rent to live in my house or to live in an apartment that I bought for them or a condo. But these are considerations that you need to make to maintain government assistance. And honestly, there's a portion of it that gives them a sense of independence if they're able to live in this way. It's really a cool thing to see when the parent and the child begin to interact in a way that's a little bit more formal. Sometimes the family doesn't want to, and that's their decision, but it is something to think about. One more thing I'll touch on is that the bond in Collin County is what we call a paper bond. It is something that gets put before the court typically. It's $50 and they don't actually ask for the money. It's just something to add this level of accountability with the court system There are other counties that will require you to post full bond. I've never experienced that. Even in Denton, I have not yet had an issue with it. Sometimes I've had them ask for more than $50. But again, Eddie may have better experience with that, but I try to focus primarily in Collin County because of the ease, and I refuse to go to places like Tarrant County because of the difficulty. But that is a consideration that you'll want to keep in mind, is that there is a bond element required for guardianship, both of the person and the estate. The estate has a much higher level, and they will typically require you to either use a suretyship, someone that will post it for you, or a cash bond. The other documents are pretty standard. The next slide is about the court hearing. This is probably the most stressful portion typically for my clients, but I try to encourage them that for me, it's one of the most exciting. And the reason is because when you're dealing with Judge Copeland and you go before him, he eliminates this overwhelming legal atmosphere that we typically see on the TV. It's much more personal. He is much more formal than other judges I've been before, and he loves to meet the potential ward. So it's usually very 15, 20 minutes, very quick. There's going to be some questions thrown back and forth. The attorney will typically ask both of the co-guardians, if it's mother and father, a few questions. Sometimes you will find that they will try to ask the child a few questions, and then it's not meant to be uncomfortable if the child doesn't want to answer. That's just the nature of it, and we all know that. And we're all there in the courtroom for that kid. So just remember that when you go into the hearing, that we're all there for you. We're not there for us. We're not here to make a show. We're here to make you comfortable and get you through the process to protect your child. And I think that's the last one. Again, you'll see an example. There's the letter of guardianship. So this is the last, I guess, hurrah, I guess, after the hearing. The judge will work with the attorney to get you letters of guardianship. They have to be requested by the attorney, and they send them to you. We usually get several of them. They do have to be renewed every year, and there's an account, or for guardian of the person, it's going to be a report that you file with the court. It's a very standardized form. I have clients that do it on their own. I have others that bring them to me and ask me to file the report. But this is an example of a letter of guardianship that you would receive from the court, and this is what you would use if you have to deal with an institution or a bank or someone to prove that you can act on behalf of the child, or in this case, they call them wards. I try to avoid that term because it's just odd to me, but that's what they're legally called. And I think the next one, Eddie, you're going to take over.
Indeed. And before I touch on the responsibilities of a guardian, just to echo what Paul says about Collin County, we're very lucky to practice here.
Can you speak up a little bit, Eddie?
Yes, I was just echoing what Paul said about practicing really before Judge Copeland. I tell because like Paul's clients, my client, it's very nerve-wracking before you go in there. And it used to be we would go to the courthouse. COVID has limited that. Now a lot of it's on Zoom, but it's still very nerve-wracking. And he does a remarkable job of just making people feel at ease, really from the moment that it's our case comes up. And I tell my clients all the time that everybody else you see in there, me, the ad litem, we're sort of part of the scenery, but the whole reason we are there is for your family and for you. And this is a very important, powerful step to make things just easy for your family moving forward. And Judge Copeland, he does, and when possible, he loves to meet the kiddo on camera, and he'll engage in conversation with them. It really is. And then when we're done, it just feels really good when we are done with that, with the hearing in Judge Copeland. And the other counties are, so assuming everything goes okay, they're fine. But we're probably spoiled a little bit in Collin County just due to the personal nature of Judge Copeland. I just wanted to touch base on that too. Responsibilities of the guardian. It's really more duties that the guardian has once you've been sworn in. And they're rather obvious, but just you do have a lawful duty to care for and protect your child, who the law refers to as the ward. And those duties they're laid out, but they're sort of obvious: clothing, food, medical care, shelter. And then you will also have the additional power to then consent to medical treatment, any type, surgical, psychiatric, anything that they just need day to day. It doesn't limit it from the inpatient psychiatric commitment. That would require some court oversight, but basic day-to-day care, going to a doctor's appointment, it just makes life very, very easy for you. There's something called the annual report of the ward for guardianship of the person. It sounds more detailed than it actually is. Essentially, every year you're just checking in and renewing your letters of guardianship. There's a form that you're able to fill out. I'm happy to help. I help my clients with it. I'm sure Paul does too, all of the time. Usually once they see it, they realize they don't need any assistance with it. And you simply fill it out, and it really turns into updating the court of any significant changes or contact address or changes there. And then the other duties and responsibilities are clearly laid out, but those are the most important ones that you've got there. Paul's going to touch base on the practical pointers. We may both chime in here, but these are things that just to kind of keep in mind as you begin the process.
Yeah, Eddie talked about this a bit before. I tend to have an initial consult with my clients before they go see the doctor. And this is where there's still a potential, let's say. And then I walk them through the process. And timing of preparation is huge for our firm, because the moment you hit the doctor and get that report, we're off and running. That's kind of our impetus to make sure, one, that we have incapacity and we know exactly what kind of application we're going to file. I think we talked enough about the fact that every county is different. And I think it is a very important thing. And Julia, what's the current wait time for government assistance? Do you know?
15 plus years for a lot of the waiver programs.
So start early is really an understatement.
It might be less, but.
Right. Yeah. 15 years is a long time to wait. So start early. And then also consider the idea of successor guardians. And I think Eddie has a really good point here I'd like him to make, we talked about before.
Sure. Because it does present the possibility that something may happen to you, and you can designate in advance who would be the successor guardian should something happen to you. If you have done any type of estate planning and you've designated who would be a guardian for your children, it's essentially the same thing.
Can I ask a question about that? I am my brother's successor guardian, but when my mom is gone, I still have to go through the process of becoming his legal guardian, though. But that will at least, show what her desire was for the next guardian.
Exactly right. You have been nominated, and there's the law in the court there's a very strong deference to who has been nominated. And essentially what would be done is just double checking to make sure that the nominee is not disqualified, is really what that is. But it's extremely important to make certain that that's in place, because it does present the possibility that you may pass, or both of you may pass, and you've not nominated someone, and it will get sorted out, but everybody would really like to know how you'd want it to be sorted out. Unfortunately, at that point, if you're not designated in advance, it's too late to ask. So that brings us to what are frequently asked questions, but also too, we want to make sure that any questions that you have that are not addressed here, we get those answered. I'll touch on the first couple of these. I did initially the difference between a guardianship of person and the estate. Guardianship costs. I know Paul and I don't know what anybody else does, but on most guardianships, the county and ad litem make more money than our offices do on these. We're just sort of passionate about it, making sure people get it done, and do not want money to be a barrier to it. At least our legal fees. Ethically, I don't even know that we'd be allowed to say what they are, but I think if you looked either on our websites or called around, you would find that they're much less expensive than you would expect them to be. And then there are fees that go with it. The filing fee, as Paul mentioned, if we can do a waiver, that eliminates the $79 fee of having other people who are required to be noticed served. But there is a fee attached with the initial citation that goes to your kid. Those are all fees, and then there's an ad litem fee. But in Collin County, Judge Copeland is really good about if we prepare and submit the proper affidavit, that $500 fee gets paid out of the county registry, so you don't have to pay that. So there's things we can do to manage those fees too. How long does the guardianship process take? At the risk of sounding like a lawyer, it depends. It depends on the county. From beginning to end in Collin County, a couple of months is probably very fair. And many times that depends on, have you gotten the class done? We're waiting on the course and the background check to be returned, or a couple little things to be done. But typically under a couple of months, beginning to end in Collin County. In Denton County, it's probably 4 to 6 months when it's all said and done. I'll let Paul touch on some of these other frequently asked questions, and then we by all means want to answer any questions that you have.
So is a guardianship the same as a conservatorship? Unfortunately, our firm is in both Texas and Louisiana. They're absolutely not the same in Louisiana. In Texas, conservatorship typically refers to something that has to deal with a suit affecting parent-child relationship, which is another word typically for divorce or custody. I'll let Eddie get deeper into that one if he wants to, but for me, guardianship is totally different. We treat them very differently. We don't do a whole lot of conservatorships because family law for us is very stressful and it makes me cry a lot, and so I don't want to do that. Do you have to wait until 18 to begin the guardianship? Go ahead, Eddie. Sorry, I didn't see you were talking.
No, I'm like you. I refer those out. Yep.
Right. Absolutely. Do you have to wait until 18 to begin the guardianship? I'm going to say no. And by that, I mean the process. There's things that we can do as attorneys and you can do as parents to begin the process now. Specifically, if I were counseling someone in our office, if they're very early on, one is begin to think towards social services or government assistance. Like Julia was saying, I mean, there's a 15-year wait list. And quite honestly, I think that's going to grow exponentially over the years. Especially under the current administration, it's more appealing for some people to seek those things out. So there are a lot of things you could do before meeting with an attorney to get started. And I know for a fact that your greatest asset, in my opinion, is sitting here at this meeting named Julia Chalker, and she has more information than most attorneys that I know. And I love her and respect her to an infinite degree. So I hope you know the resources that you guys have in the district, because I know that they have a great program. She's asked us to be here, and we wouldn't be here without her. So,
Paul, about that, as far as, and you're right, there's so many different things they can be doing before this. But as far as actually starting the process, would you say with an attorney, would you say 6 months before they turn 18? That's kind of what I've told parents.
Yeah, and that's probably the high side for me. I think 6 months is a great time to begin thinking about it. And I think Eddie would say the same thing. I think we talked about this before. I think he starts sometimes with clients 6 months in advance. For us, honestly, 3 months is plenty. 2 months, 30 days, really. It just depends on how flexible or up to speed the parents are in terms of getting ready for the medical exam and the certificate from the medical examiner. That's really my big trigger personally. At this point, I think Eddie and I both have been through the process enough that once we have what we need, buckle up and just get ready. And then we'll prep you up for hearing and enjoy it as best you can. And then for the future, hopefully we've gotten you to a place where you don't have to worry anymore, that you feel safe and secure in the way that things have gone, that you can go forward with real confidence in how your child's going to be cared for in the future. So long answer, 6 months. Eddie, you want to pick up the next ones?
A less expensive alternative to guardianship, we touched on those earlier. There indeed are. However, many times the guardianship, Yeah, many times in the best interest of your kiddo and for you to be able to just sleep better at night and make sure that they're cared for and going to be safe from really just about anything. And even in case of emergency, the guardianship is the way to go. I mean, if the court is good with it, and we will obviously investigate that before we get too far down the road. But if Paul and I and any lawyer says, yep, it looks like at least some form of a guardianship is the way to go. I've never had a court stop and say, no, we disagree. And that's, partly because we do, the check all the boxes on the front end. And ultimately the court, doesn't matter which one you're in, their best interest is your child. And they're not looking to make things more difficult for you in your care for the child. Sometimes they do feel like they're looking to make things more difficult for the lawyers, but that's not your problem. That's what the lawyer is there for, and for you not to even feel that and notice that. So yes, by definition, there are less extensive alternatives, but when a guardianship is necessary, that's what we will do. And Paul touched on earlier a special needs trust for your child. And the short answer is probably so. Even to the extent where when you're doing some estate planning, or if grandparents want to leave some money to all of the children in a family, and one of them may be in need for a guardianship, and we want to make sure that we manage their assets, we could set it up to where in their will, whatever would go to the children who are not under a guardianship could go to them directly. However, instead of going directly to the kiddo who needs the guardian, then it goes into a special needs trust, and it's to supplement all these other services that they're receiving. And whoever is listed as the trustee, which is a fancy word for manager, to manage those for them for their benefit, they can use that pretty liberally and pretty broadly. But the kiddo is never allowed to have any management control over it, thereby not raising their estate above the threshold that gets rid of any services. And so there will come a time, if they're going to inherit anything from you or from anybody, that there's a way to make certain that that's taken care of on the front end. All right. That's a lot of me. Nobody wants to hear me talk anymore, I'm sure.
Let's see. One second. Great. Okay, we are back. That was such wonderful information for everyone. I'm sure we have some questions. Let me look in the chat and see if there's any of that there first. Nope. Okay. Okay. Well, let's open it up for any questions that y'all may have for Eddie and Paul. You can just unmute yourself and chime in if you have a question.
Do either one of you guys help with writing wills and things now? Because I have, learning all of this, I have to rewrite our current will. Is that something
we both do? Sure, we both do. Yeah.
I'm new to Texas. I don't have a lawyer anymore, so I have to start over from scratch.
Depending on where you are geographically, if you're not, we could always help you find somebody close to you as well.
Okay, thank you.
Oh, certainly.
I have a question. Oh, sorry. I have a question. It's a long way out. But like if I saw the beginning, like marriage, driving, if you say he's about to be 13, so we're kind of a long way out, but I'm just curious if they want to get married or have a car or whatever, and if you say no, can you go back and undo things if things change? And if they do get married, does that affect them with benefits or just them being special needs? I'm just curious because I know a couple that had significant delays and they couldn't get married by the state because they would take away their benefits. So just kind of curious about that aspect.
Paul? I keep jumping in. You're free to.
So I've never had anyone try to get married outside of court after having a guardian appointed over them, specifically with the right to marriage being removed. I'm not really sure, to be honest with you, about that. Eddie may know. I know that you can go back and.
Yeah, go ahead.
Sorry, go ahead.
I think I cut you off, Paul.
I don't know what the impact of that would be, to be honest with you. Eddie may know, but specifically as far as going back to the court to have things amended, that's always a possibility. There's just going to be a process and a cost associated with getting those things changed. It's just like if I were to go in and I would have rights available to them, such as to vote, to get married, or to drive, but then later we realize that's not supposed to be there, or that's not possible, it's not something we should have done, you can go back and petition the court to restrict their rights even further. In the same way, you could, even after getting a guardian appointed over you, you can go back to the court and petition them to restore your rights. It's not something that has never happened before, because it does. We've gone to court before for people that we know that didn't even know that they had a guardian appointed over them. I know that sounds ridiculous, but things happen in the world. And so we were able to go back to court and get them fully restored to capacity so that they could begin operating and living like a normal life. Yes, it's possible. Long answer. Eddie may know better about the marriage thing. I'm not honestly sure.
I have also not had anyone do that. I do know when Judge Copeland, he's very conversational in the hearings, and he will say that if things change, he said, you're not going to have to come back to court, but if things do change, we can adjust this, and that's what Paul was touching on. So I don't see a reason why, if somebody did develop the ability to marry, that could be looked at and be adjusted. Sure. And with regard to the benefits aspect of that question, my expectation is it's probably benefit specific, depending upon what the benefit is and the reason that they're getting it.
You have to renew your letter of guardianship or whatever every single year. Can you choose to not at some point? Like if he turns 23 or 25 and I decide I think he's got it figured out, can I choose to stop? Or do I have to go back through the courts to say he is okay now? Or how does that work if I?
They are typically written to go forever. However, should circumstances change and someone regain their capacity, because there are guardianships that happen and they're going to get better. And so then you could go back to the court. You would have to go back to the court and ask them to close up the guardianship. It can be done.
Right. And one thing to add from prior experience, if there's an instance where you're not reporting back to the court as they desire, there is a potential risk, and I'm trying to choose my words carefully on purpose, but there is a potential risk that you run by not staying current with the court, that the guardianship still exists. In other words, the rights have been terminated from the child, and the court is going to seek someone to be a guardian over that child. So it may be you because you're going to go back and get right with the court, or it could be someone else. I just think that's a potential risk. For me, maybe I overemphasize and get them motivated to file their reports. And it may not be a risk that really should be addressed. But for me, I think about it in terms of what are my risks for my kid? And if there's a risk that someone else could be appointed guardian over my child just because I didn't file my report, I don't think it's worth it.
So if at 18, I feel like he's not ready to be responsible for himself, but at 25, I do, I have to go back and undo it. But that is possible, or it's not? Like,
it is possible. So what's happening, and at least the way that I see it is, when I go to court to get the guardianship, they're stripping rights away from the child. So they no longer have these constitutional rights to act. So they can't go vote, they can't go marry, they can't drive a car. They have no contractual right to contract with any other third party. So to change that, I go back to the court and tell them, hey, they're ready. Go reinstate their capacity and give them their rights back, and the court does so, assuming that all is well, right?
So not completing your annual report doesn't automatically undo the guardianship. You would have to actually go through the process.
In my opinion, yes.
Yes, I agree.
When you do the guardianship, can you put a time limit on it? Can we just say, I need 5 or 7 years or something more because he's just not there yet? Or is it just permanent?
So typically you would determine that up front. Temporary guardianships are possible. I don't know if they would meet your need. And I can't really specifically state, but so yes, temporary guardianships are a thing and permanent guardianships are a thing. We have done one temporary guardianship since I've practiced. Granted, it's not near as long as Eddie, but I find them very uncommon. And typically they're for a specific reason, that there is an immediate risk to the child, their health, safety, that kind of thing. I honestly don't know a direct answer to your question. I would have to research a bit more in terms of, can I request a temporary guardianship for 5 years? I don't know. I think that's difficult for me to stretch to think to do that, but Eddie may have better understanding of that.
Sure, I too would have to research it. However, my gut tells me no, and the reason is because if you truly know that it's going to be a fixed period of time, then there's probably an alternative they would use instead of guardianship. It's arguably not scientifically possible, I'm not a doctor, to know when someone's intellectual disability might end. And so I think a court they'd be very, very leery about if the law would even allow them for a guardianship on an indefinite period of time. And back to Paul's point on temporary guardianship, that's exactly my experience too. Temporary is sort of in case of emergency, or let's speed things up, but it's temporary only because we need to get it fast tracked. It's temporary on its path to permanency. It's not temporary and that's going to be it. It's just going to be temporary. We need it temporary because we need it yesterday. And we're on our way to get the permanent, but we need to speed things up and we need these in place right away. At least portions of it right away.
I mean, because obviously I don't know. I just don't want to give up hope that someday he.
No, you're exactly right. And nor does anybody else want to give up hope or want you to give up hope. And that's key in this process. This is not giving up things forever, because with hope, which is extremely powerful, and many times people's situations do improve. And it's really not difficult. It feels difficult because there's lawyers involved, and anything you can do without a lawyer, I recommend. But this requires lawyers to go back and get it changed. And courts love to do that because it's exciting. And the court they're not going to keep someone under a guardianship and limit their right to marry if they can marry. And Judge Copeland in particular says with the right to drive, if the DPS is going to give them a license, it's fine with me. And so, no, don't give up. You'll never give up hope, and nor would any of this require you to give up hope. I think that the law would have a tough time putting a fixed end period on it, but you could look at that in a positive way too. If they put a 7-year fixed period on it, and in 3 years everything's better, then we just go back and get it changed earlier. But then the counter argument is, no, you said 7, you got to stick with the 7. If it's indefinite, and there are mechanisms in place to reward that hope by either getting rid of it altogether and restoring their rights, or even limiting it at that point. Sure.
Right. Yeah, and I think that's another key too, is remember that you have the ability to change the guardianship provisions, so you could go from a permanent, all-encompassing to permanent limited. So you could begin to trim back on the restrictions so that you grant more freedoms and they gain more rights over time. but you're still going to remain under what we would call a permanent guardianship. So that way, your hope's not lost at all. You're able to document progress as you see growth. So there are tons of options out there. The law is meant to accommodate. One great thing Collin County as a court says, we're not vindictive. We're not here to harm you. We're not here to make you pay for penance of something that you've done. We're here to help you. So keep that in mind.
Well, we are about out of time. Are there any final questions?
Just a quick question. Does either one of the lawyers, take prepaid legal to pay for attorney fee? Like my husband has prepaid legal through his job. So do you guys take that and paying for like guardianships and trust and all of those services?
My office does not, but presumably, and maybe Paul knows, maybe Paul's does, or he knows he can offer a little bit more. That program might have lawyers to whom it would direct you to make best use. Because if you've prepaid for that, I would certainly want to look into that if I were.
Right. And that's my experience too. We don't typically either. We have tried in the past, but we were not on the approved list. Toyota's a big one. So we have a ton of clients at Toyota, and I know that the majority of them pay for something similar to that, but they were limited to attorneys that they couldn't go in person meet with because maybe their location was different. We were just down the street, and so a lot of people just ended up coming over. But they typically have a prepaid or pre-approved list of attorneys to use, or they take someone inside and refer out. So you may have a contact attorney, but they may have someone else do the work. I know that sounds crazy, but that's one of the benefits of the prepaid legal.
I guess having an attorney that has background and understanding of special needs is really, really important. Would y'all agree? So.
Yes. Yeah. You just, if they're going to, and everybody has the right to their own lawyer, and just make sure that through that service you're getting taken care of. I mean, they'll have an ethical duty to do everything right. But of all of the things that Paul and I do, I think this is at least for me, it's the most personal. It's where I get to know families the most and develop long relationships with them. And so, yeah, you just want to make sure you've got somebody who is available in there and knows their way around the particular county courts.
Great. Well, you guys have been awesome. Thank you so much for sharing your expertise and experience with us. I am going to post a recording of this and the slides, and it'll have their contact information if you think of any other questions you want to follow up with. And thank you again for coming.